The lower appellate court has held that it was not open for him to do so, but that he should have paid the same court fee as the plaintiff had done in the trial court. And paragraph number 4, my lords, that is the discussion of the first court. The last 4 lines, the submission of the learned counsel for the appellant that the present case is governed under section 49 explanation 4 appears to me not tenable. It is my view that this case is covered under explanation 1 of section 49 of the Mysore Court Fees and Suit Valuation Act. Parameter. Para 5. But there is no dispute whatever on the first proposition made by him that even for getting rid of the first respondent, clearly of the opinion that court fee under the Court Fees Act is payable not in respect of a finding, but in respect of the relief claimed by him. It is also undisputable that court fee in an appeal is paid in respect of subject matter of the opinion of the Court Fees Act and explanation. No, Malas, this is not. There's one more judgment which may be a little more apt to this case. So, Malas, please, Malas, paragraph 6 and 10, Malas. The fact that even for getting the restricted relief, it is necessary to persuade the appellate court to reverse the finding of the trial court on the question of nature of the ownership of the property is no reason for holding that he should be asked to pay for the court fee on the entire property which he had made in the subject matter of the suit. So in the suit, he had asked for the entire property. In the appeal, he had claimed it to 1/3. Para 8 also sheds light on the aspect of how different than the relief claimed in the suit, because a larger relief than what has been claimed in the suit is never capable of being claimed in an appeal.
Is it peculiar to the Karnataka Court Fee Act, or is it something parameter across India in all the local court fees acts?
My lords, this I found also in so far as Patna and Nagpur is concerned. Similar provision. It is also relevant. It's referred to in the subsequent paragraph, subsequent judgment. My lords. That starts at page 51. This is H. Shrikantaya versus the Indian Institute of Science, Bangalore. My lords. Paragraph number 2. The appellant Shrikantaya presented his plaint in a petition under Order 33, Rule 1 of the Code of Civil Procedure, seeking permission to sue informa pauperis in the court of the First Additional Civil Judge, Bangalore City, on so and so date. On seeking permission to sue informa pauperis, Sri Shrikantaya challenged the said order in this court in civil revision petition, so and so. On 10 January, this court confirmed the order made by the court below on 9th July 1974. The learned single judge who disposed of the said revision petition observed in the course of the order that the question regarding applicability of otherwise of section 40E of the Karnataka Court Fees and Suit Valuation Act is left open to be decided, and therefore appealable under section 96. Sri Shrikantaya then, therefore appealable under section 96. Sri Shrikantaya then filed civil petition seeking permission of the court to prefer the appeal as an indigent person. He also filed IA number 1 in the said civil petition for condonation. When this was a position, CRP number so and so filed by Shrikantaya was dismissed on 3rd December 1976. And on 28th January, an order was made by the learned single judge rejecting the application of so and so for condonation of delay. Though the clear effect of the order made in so and so was not only to reject IA number 1, but also to dismiss the petition itself, Sri Shrikantaya made an application seeking a direction to the registrar of this court for an order on the grounds the same has not yet been disposed of. Allows 2 lines thereafter. Against the order made in CP number so and so, Sri Shrikantaya preferred original second appeal number so and so, and that appeal was dismissed on so and so as not maintainable. Thereafter, he filed seeking to prosecute the appeal as an indigent person. His submission, which if accepted, would bring substantial relief to Sri Shrikantaya. It was maintained by so and so that Sri Shrikantaya cannot be called upon to pay court fee of rupees 5,335 on the memorandum of appeal on the ground that this was the amount of court fee which Sri Shrikantaya was required to pay on the plaint in the court of the first instance. It was contended He maintained that the subject matter of the appeal is only one pertaining to proper court fee payable on the plaint, and in regard to the propriety or correctness of the order of the court below, rejecting the plaint on the ground that the appellant has not paid the court fee demanded from him. The lower court had asked for the court fee to be paid. That was not paid. It was thereafter subsequently challenged. And the propriety of the order of whether the court fee was to be paid or correct or not was the subject matter of the challenge.
What is the conclusion drawn
Please, my
by
lords.
the appellate court?
My lords?
By the appellate court?
Please, my lords.
200 would suffice.
200 would suffice.
What is the reasoning?
Please, my lords. 6, my lords. Paragraph 6. It is therefore clear that the relief claimed in the appeal is different from the relief prayed for by the appellant in the suit before the court below. Hence, explanation 4 of section 49 of the Act is clearly attracted. That being the position, the appellant is liable to pay court fee on the memorandum of appeal payable in the court of the first instance on the relief which the appellant has prayed for in this appeal. In substance, the claim of the appellant is to get rid of the order of the court below requiring him to pay the deficit court fee of 5155. It is on the amount that the appellant is required to pay ad valorem court fee, which comes to rupees 387. The view that we have taken clearly flows from the language of explanation. What the parties are liable to pay is the fee. What the parties are liable to pay is the fee and not tax. The fee payable has to be commensurate with the service rendered to the party. When at the appellate stage there is no scope for going into the merits of the case, he cannot be expected to pay the same court fee which he would be required to pay for the entire adjudication of the dispute.
Okay. Just say that on the date of hearing, an issue of as the registry has issued on the last date of hearing, as the registry has raised an issue of payment of both of these appeals, we deemed it appropriate to appoint Mr. Srihari as advocate as an amicus curiae to assist the court on the objection of the court fee. 4.2, Section 49 of the Karnataka Court Fee Act. Karnataka Court Fees, Suit and Suits Valuation Act 1958 shall get attracted. But tell us one thing, Mr. Kumar. How would the appeal be maintainable? How would be your appeal maintainable? Because if you see under which provision you have filed the appeal.
May I address?
Yeah, do that.
Firstly, I reserve the right to, should the issue of maintainability be raised, the maintainability of the appeal, to seek time to argue against it.
That's why we will tell you, we will just clarify our point with the show.
CPC address this matter because it is quite.
Please.
See the new judgment.
Please.
Page 92, Your Honor. The operative part is on page 92 of the book. the same thing. This was slightly corrected because of a typo. This is the same thing, same thing. But because they made an error in the partition, and this is the same thing.
Statement, but they have not pressed for it. They've continued with the case as they wish to. Statement, but they have not pressed for it. They've continued with the case as they wish to.
Can there be a issue on the maintainability of the suit, having not pressed their prayer for referring to arbitration as a preliminary issue, and the court going into that? It's like that. Though I have not filed Section 8, though I have not taken a plea in my written statement that this is referred to the arbitration, but I am taking an objection, and that should be an objection which should be framed as a preliminary issue. And the court going into that and then deciding that.
Please.
Things circumventing the process.
Please, Manoj, because there's also the concept of producing the original 8-2 and all of which.
Yes, sir. Wait, what did we say then? On these two judgments, the paragraph so and so of the first judgment